Still listening to our Good Morning Salon, where they come to you from the Society for Radio Democracy 98.1 FM. As you get from one Power headline stories, them today we go talk to the Executive Director for Center for Accountability and the Rule of Law, Carl Ibrahim Tommy, where we can talk about the criminalization and the classification of petty offenses. Well, we don't welcome another the studio for somebody the listener Carl na leading civil society organization where they work for defend human rights, promote justice, accountability and equity na Salon. Inside 2017, Carl and advocate being received funding from Osiwa for advocate for the removal of offenses them we then describe as petty crime. Within a petty crime to Carl estimation inside this campaign and how far Carl Lewita make we get Ibrahim Tommy the inside the program and later get for states Carl and position on the issue of the University of Salon and the Minister of Basic and Senior Secondary Education. Good morning, Ibrahim Tommy, and welcome to the program Good Morning Salon.
Good morning again. Thank you very much. I'm glad for there.
From that little background we had on from 2017 una day on this campaign and you and una partners them. Before we can look at within a petty crimes and how far una they with the campaign, within the Apuna Carl or within the Apuna Carl in relation to una work as I read just the background.
We don't do plenty thing as an organization. As you rightly point out in your introduction, they work on a number of issues, principally one for ensure we promote a culture of human rights, ensure that rule of law prevail, hold public officials to account, but also ensure that we all grow collectively. So over the last perhaps year or two, we done the work on a number of initiatives, including ensuring that we get an accountable electoral justice system, make sure we participate in the elections, we do court monitoring. We also engage in research and publication. We provide voice. We mobilize communities for ensure that they are involved in governance, especially at the local level. So there's a lot that we've done the work on over the last year in particular. But on the issue of petty offenses, indeed, Carl and Advocate way back in 2017 joined the campaign, and I should say it's a continent-wide campaign for make sure offenses we then call petty offenses, we decriminalize them, meaning the laws then they make them criminal offenses, but they push for we make sure they are not criminalized, we decriminalize them or we declassify them. Now, as I say now, a continent-wide campaign, even the African Commission don't take a position on this. So we in our Salon, we just continue this campaign. We a continent-wide campaign for make sure we protect citizens. And the citizens that we the campaign really seek for protect are the most vulnerable, the poor. Unfortunately, it includes women who are disproportionately affected by these offenses.
Okay, looking at the issue of petty crime or offense, different people get a way how they can interpret them or call them. As you dare now for talk about this issue and something that they campaign against. In your legal words, how you will best describe petty offense then? Okay,
so this not to me young words some but within the experts, like I said, in the African Commission, and we on study now. And by the way, Sabtimeka prefaced with this comment that when we start this program in 2017, this project in 2017, we undertake a study, a baseline study. Across the country, we look at the number of cases before the courts, especially the magistrate courts. Of the 718 cases we captured, 33% of them, we call them petty offenses. Now, back to your question. What's now petty offenses in the context of Salon? These are offenses where the laws and create, but they're vague, and because they're vague, sometimes or most times, in fact, they can be wrongly applied by law enforcement, and also the punishment within the method for them offenses there is disproportionate. To the gravity of the offense. You understand? And invariably they lead to violation of human rights. So now them four ingredients now we get for characterized petty offenses.
Okay, in line with that, you can state some example of, any crime where somebody will commit we fall under petty offenses.
So keep in mind, I don't use some characteristics of petty offenses. What we do this study, one of the offenses we call petty offenses. We say minor traffic offenses, for example. Like you they drive, you not get park light. Don't get me wrong, we're not saying you for drive without a park light. We know they say if you obstruction of traffic not to offense. No. We are saying the punishment, you understand, disproportionate.
That is too big for the
too
offense.
big for the offense. Then one. In terms of wrong application of the law, now you cannot really say, person, you can't take that. Musa, when I there, you jam. There is supposed to Musa, let me buy 100,000. Where my salary come, I go pay you. Then salary cannot pay Musa. The next thing Musa they do, if they wrong with the police, this is not a purely civil transaction I don't get. Now debt. Now civil courts for handle them. But because in we laws we get there's an offense who get to them called obtaining money or goods under false pretense. You now go to police and talk say, oh, Musa talk say like get money, they go buy clothes and can't give me back the clothes or something. You create a story and then the police involved now. Now something that be purely civil transaction, then convert into criminal, they arrest you, then detain you, you go down. And at that they happen most times. Now, ultimately, like I said, why could they even call them poverty? These are poverty offenses. They affect and say, "Bra, how they left we?" You understand? A driver go. You, when a young man or young woman, mostly young women, you they walk along the beach. They wait for motorcar or they fen keke or fen okada. There's a police van where they driving, pick you up, bam. They say waiting, loitering, because even the law, the way it was drafted is so vague that they can arrest you for loitering because you have to give an account of yourself according to the text of the law.
Okay, you just relate their offenses here to a poverty one. Another angle they say, is it that people not can know much better waiting for do, or in any way you think say it make much sense for let you relate some of the offense here for say they affect most vulnerable people?
Absolutely, the research shows that, and for example, loitering, most people are homeless. Not only in Sierra Leone, but in other parts of the continent. If you're homeless, you not get time for sleep, you are wandering about. And the law basically they punish person they wonder about rich people. You understand? If you get place for stay, you're not going to wonder about. So the way to they basically say is, they say these are not acceptable conduct. They say if you take money from Musa, enough for pay. Or not they say if you just about the wonder, you not get place for sleep. But believe me, people and they not get place for sleep. They are homeless, so they are poor. But the way how they punish people for their conduct and some of them conduct that they not mean for go thief money, they just mean for go do business. Think of the woman at Abacha Street where they go take clothes from the Lebanese man in the man or even Salon man in shop. Say I go sell, I go we run. Where I make money, I can't pay. It go business go bad. The next thing you read, this is not a genuine businesswoman. The next thing you read, you go to police. And the reason people run to the police is simple. Because we all believe, say, once you seize person liberty, you detain them, you send them go down. In family, go gather money, they can't pay you. It's because of that they misapply the law. So that misapplication of the law and the disproportionate sentence where the offense and the create. Now really they push for that we revise the laws and make sure say it consistent with human rights obligations.
From 2017 to date, now a very long period on this campaign.
Indeed.
From Salon perspective, as you say, a global campaign, what do you identify as the root cause to some of these issues then?
Now the laws. Clearly, we don't identify the laws, then we get all them petty offenses there. The Larceny Act is one of them. The Public Order Act then create loitering. You understand? So all into the fraudulent conversion. Again, the Road Traffic Act and the regulations. So these are the laws we create then offenses there. So we don't identify them, or we don't make specific recommendations. So in addition to the baseline report we don't produce, there's a position paper we identify each of the provisions of the laws where they create this situation, and we don't make specific recommendation to the office of the Attorney General and Minister of Justice, even before the current one, by the way. And I'm pleased to say that the Human Rights Commission has also been part of this campaign, and we're working collaboratively with not just the Human Rights Commission, but with other actors for make sure, say, the government of Sierra Leone decriminalize what we call petty offenses or what we call poverty offenses.
Okay.
That calls for amendments.
It does, yes.
How far una don't go with that advocacy?
So now they within now. So with the hope, say, in the not too distant future, maybe this week, next week, we get for approach the office of the Attorney General Minister of Justice for make a commitment to this, because as I said, we don't get documents, we don't prepare papers, we don't get a review, and there's everything in place now for that. It's just a question of commitment on the part of the government for say yes. And by the way, we have in the past received the commitment from the previous AG, maybe they did again commitment, and I'm absolutely confident that the current AG will gain commitment, and therefore perhaps we could just go to call, like how we abolish the death penalty. We just look at the different provisions in the laws and where they provide for death penalty, we abolish them. So maybe we can get we already talk about equality before the law. And like how the TRC report say, it say the law for time like close, for fit
Everybody.
the person where they make them for. Where they feel say the law not fit, especially the poor people. If somebody is homeless, they punish homelessness through a law way as old as 1965. We're saying homelessness, the responsibility of the state in the first place for make sure that people get access to public housing. We not get that one day. Not punish person 2 term. If person go take debt, that's why we have the magistrate court, we have the high court. Now civil matter, good day, not go na police season liberty and send a go down. In fact, now they make overcrowding. Now the correctional center they as well. So ultimately, and this is where we coming as a center, we think that it lead to violation of rights.
Okay, continue for the with me. In name na Ibrahim Tommy, in the executive director, Center for Accountability and Rule of Law, CAL. There they talk on the decriminalization and disclassification of petty offenses. When we say some of the small crime the way people can commit, the punishment where they can get into A before them. The program Good Morning Salon they continue, and inside the program we welcome with other studio guest Musa.
Yes, we want to welcome the Public Relations Officer for the dissolved University Court. We James Tambalebi. They can talk about waiting at them position on the dissolvement of the University Court. Good morning, James Tambalebi, and welcome to the program. Good morning, Salon.
Good morning, Musa. Good morning, sir, to you, and good morning, listener.
Okay, quick background for we listeners and viewers. Just last week, the Minister for Higher Education announced to the public, say they don't dissolve the University Courts. We're the highest decision-making body now, the University of Saloon, and University of Saloon get for do it from Bay College, College of Medicine, and Allied. Government of the University Courts.
Yes, we are. We are. the President of the Republic, now been the Chancellor of all public universities. And then, because of a busy schedule, the law make provision for a pro-chancellor. So, the powers of the chancellor then, now the pro-chancellor of the university will have been chairman of the court, and the Ministry of Education, now they will exercise them powers then on behalf of the president, now the chancellor. Now, fast forward, some amendments they may not happen till 2018, but before the 2018 elections, the then candidate of the Sierra Leone People's Party, Mr. Madabio, now President of the Republic, President Julius Madabio, campaigned on a manifesto say if they elect him, he will divorce the position of the President of the Republic of Sierra Leone from the Chancellorship of Public Universities. And true to his word, he win, he deliver. And for drive, puts that into effect, then change the law, then repeal the 2005 Universities Act and replace them with the 2021 Universities Act. Now, a major paradigm shift. And one major thing is that the President of the Republic, excuse me, cease for be Chancellor of Public Universities. Then he appoints chancellors for all public universities and transfer majority of him powers them. So then chancellor then they. So the president remain as visitor. Now, then the new act, also, just like the old act, it get a position of a pro-vice chancellor. So when you look at sections 8 and sections 9, they're very instructive. Then show the powers of the chancellor and the powers of the courts. So the powers of appointment, the appointment of the higher officers of the courts of the university, now the business of the chancellor of the university and that of the university courts, and no longer that of the chancellor.
Okay.
So that's not the backdrop.
Okay, after that backdrop, they will come back
So
to
now
you.
we
We'll go for a break, please.
All right, okay.
Continue for the with Widana, the PRO for the dissolved university court. James Tambalebi, where the state then position on the court where the Ministry of Technical and Higher Education closes behind them due to some controversy. We will come back to you inside the program now. We will go for a break. Continue from that break though, they come over to our studio guest and we bring in James Tambalebi for like continue. Also, I stop as they for talk about the dissolved university court, especially for know their own position in this whole situation.
Yes, so as I've been saying, one major paradigm shift from the old law, the 2005 law, Universities Act, to the 2021 Universities Act, now the powers of appointment. It clearly stated that for appoint the vice chancellor and principal, substantive, now the vice chancellor, now the chancellor for Duam, the chancellor of the university, and for appoint the pro chancellor of the university, now the courts for Duam, and the chancellor now the chairman of courts. So this whole crisis starts on the 11th of December when the MTHE, the Ministry of Technical and Higher Education, appoints Professor Lawrence Kamara for be acting vice chancellor and principal, a position that is not even in the act.
Never exists.
It exists in the old law, but not exist in this new law in other day. So on 13 December, and this happened when the substantive holder, Professor Fodesa, was still in office, albeit them in appoint and for go ahead a new agency, the National Public Health Agency. He not been done left office it. So he handed over on the 13th. And on the 18th December, the courts convene in an extraordinary meeting for look at the development. Then frown at them, majority of the members frown at them and say then go put together a committee, a team, for go engage the MTHE with a view for persuade them, say, what's in and don't do so, in no right, they outside the law, they not get right for them. And indeed, then puts together a team, then go engage them. Then say, then they stand on their position. In fact, then write a position paper to the courts and make two arguments. Argument one, then say by appointing Professor Fodesa, automatically there was a vacancy and the university not fill the vacancy. Therefore, then they fill the vacancy. Argument two, then say they not recognize the pro vice chancellor as provided for in law because they not see any minutes where explain say he was formally appointed. The counter argument by the court is that no, there is no vacancy because there is the law make provision for automatic succession where the vice chancellor know they, and I will make reference to the law now. In section 8, subsection 5, it says where the office of the vice chancellor and principal is vacant or if for any reason he is unable to perform the duties of his office, the pro-vice-chancellor shall perform the duties of the vice-chancellor and principal until the vice-chancellor and principal resumes his duties or another is appointed in his stead. So this whole standoff now over the tentative occupation of that seat will not go to the substantive holder it. And the law, they say there should be a pro-vice-chancellor. Whether the vice-chancellor there or not, the position gay. And the university court's been done approve somebody for hold that position there in the person of Professor Samai. As a matter of fact, Nafrube College starts for hold this position. Then there was a rotational agreement after Nafrube College, now being account to Professor Samai. And the person who they appoint illegally by the ministry for can be acting vice-chancellor, he was the pro-vice-chancellor when he was DVC of Nafrube College, deputy vice-chancellor. But because they're not extending term for a second term, automatically lose the position of pro-vice-chancellor because the law, they say, a university, section 9, subsection 1, a university shall have a pro-vice-chancellor who shall be appointed by the court from among the deputy vice-chancellor. So the one condition, the key criterion for becoming a pro-vice-chancellor, you must be a sitting deputy vice-chancellor. So the courting argument is that, one, there is an arrangement where it don't take place over a period of time, and because they practice over a period of time, is acceptable in law. So you cannot say it's not properly seated. Be that as it may, the court meet on the 16th and formally approve Professor Mohamed Samai as pro-vice-chancellor, we mean in the absence of the substantive holder of this position, the position of the vice-chancellor and principal, Professor Mohamed Samai as pro-vice-chancellor can act as vice-chancellor and principal. Now the disagreement that will lead to the dissolution of the court.
Quick clarification.
I really want to
Go ahead.
Yeah? Now, this is a situation where the university court, they in conflict with the ministry. Then, boom, they say we don't dissolve now. They became a judge in their own case, which is we're on counter to the spirit of natural justice in the first place. Second, here is by dissolving the court, essentially, you don't sack the chancellor of the university, appointed by the president. The minister, the head of the ministry, is a presidential appointee. The head of the university court, now a presidential appointee. Here is one appointee by the president. It is sack another appointee. We get no basis in law. Now look what they don't do. They don't discard the Universities Act completely, and then say they replace it with a University Management Oversight Committee. This is an extrajudicial powers. You cannot say there are lapses, according to the argument. You cannot say there are lapses in the court. You dissolve them. And if you get the power, according to them, for dissolve court, you should have the power to reconstitute the court. They not reconstitute the court. Then go sit and form a committee outside of law to run the university. This has all the hallmarks of a coup. This is a ministerial coup against the University of Sierra Leone and by extension, public universities.
James Tambalebi, we can't do clarifications and follow-ups on plenty things that we don't talk about, including the issue of Professor Samai, where the university court, according to Ibido, appoint as the pro-vice-chancellor, where the ministry no recognize because of the positions that we hold. But earlier, before this term, you have been the spokesperson for the University of Salone.
Yes.
Just during this saga, let's come out say they don't sack you from your position as the spokesperson for the University of Salone.
Yes.
And today we host you as the public relations officer for the dissolved
Spokesperson.
university. Spokesperson for the dissolved university courts. How we reached it?
Yes, fine. So when this standoff starts, the court's been very, very reluctant for go public. So then try to engage the ministry. Because them still say not to get headway for convince the ministry that the powers they exercise they beyond them and it's not supported by law and it's not in line with the law and order. So then decides say now we have to go public. So the court officially mandates me for begin talk on their behalf. So in addition to being the public relations director of the University of Sierra Leone, I became then the spokesperson of the university court during this standoff. So yes, they relieved me, and this is very important to explain. Then say they relieve me of me contract. We are still the 1 year for serve. But then the interesting thing is the person who then say give the order for relieve me, when are the acting vice chancellor and principal appointed by the ministry, he resigned before they relieve me. And then say na indirect. We just know. And me believe, say, the ministry, apparently, 90 directives for letting terminate my contract because they want silence me. But I remain the spokesperson of the court.
So in all of this issue is like a don't under the boil and all of that stuff. Somebody got to wonder why James Tambalebi no be come out and stand up for what he believe in. Rather a wait when say don't be hit by the bullets. Now they can see all this.
No, I know wait. One, Nana they come now Radio Democracy, but been on there other platforms them. But more importantly, the court's been reluctant for go public because they feel say engagement, dialogue, will yield a fruitful outcome. And we will prevail on the ministry for let them understand that what they do is not supported by law, that this is not due process, and then for follow due process. But because they reach a point where they not succeed for convince them, now then authorize me now for go public. So that's how I begin to talk on the matter. They were very much constrained because they feel say then go dialogue and reach an amicable solution. But because solution nor come and dialogue no yield solution, so they decide say now we should start talking about it.
Now, let me look at the issue of Professor Samai, where you make mention about where this whole issue surround where the university court, according to Ibido, appoint as the pro-chancellor for act in the capacity as acting vice chancellor
in the absence
of the one way President Bido appoints.
Yes.
But the Minister of Technical and Education be appoints Professor Lawrence Kamara.
Yes.
Because they point several things. One,
two arguments.
Yes, Professor Samai gets some positions that we already hold, and plus this one, he go add also in responsibilities as acting vice chancellor na Kumas, and also they not see minutes now when meetings them we approve Professor Samai. Where according to the minister, if he been see any minute, they need to dissolve they need to go ahead and make another appointment. That's not the argument from the ministry.
Yes, the counter argument is that one, if they don't practice something according to arrangement over a period of time, it becomes a custom and therefore acceptable. However, we recognize that lapse and then right the wrong on the 16th of January, even before then dissolve the court. But let's even agree without conceding that this is illegal. What the ministry do is to correct one illegality with another illegality. Then go appoint somebody where one don't pass retirement age, two, not a sitting deputy vice chancellor. So that's unacceptable. Again, if Professor Samai, as they argue, he gets a lot of work on in hand, the law they say anybody they act in that position for be a sitting deputy vice chancellor. You still have Robe College, the head of Robe College. You still have the head of IPAM for function and perform that duty until such a time when they go put together a search committee. But then discard all that, then put the law aside, then go appoint somebody outside of the law. So that argument is clear-legged. It's not tenable.
So in all of this, Mr. Alebi, another angle would say the highest decision-making body, when at the university court, why they give so much space, to another body for take a decision in some people for don't speak against or knowing the fact say, una get the right and the power for do so?
No, not to space we give them. We give space to dialogue. We give space.
But the dialogue decision is wrong from all which you say.
Yeah, yield, come to fruition. So now we begin talk. Basically, this is an outside interference, and then they use raw power, for bully and coerce the university court into accepting illegality.
As I say, what do you refer to
exactly?
I
refer to the Ministry of Technical and Higher Education.
Now let's look at the fate and status of this university court. As you did describe and say, the ministry not get the right for dissolve the court. So what is the status of the court now? According to the ministry, it is dissolved. From what your standpoint, how we can describe the court?
Well, we not recognize the decision of the ministry, but the court is constrained now to work because some people are so vexed that then decide say then they watch for see what's in the happen. So what's in the non-do now? The ministry don't set aside the law. They don't send the finance director on leave. They don't send the registrar on leave. They don't handpick people them. They don't appoint them. Essentially, the university don't become a unit of the Ministry of Technical and Higher Education. Directly controlled. In fact, directly run, not even controlled. Run by the ministry. So this is an interference. And a run counter to the mischief where the president don't address. address them in the sense that they take away political and outside interference from the running of public universities and they give autonomy to the university for run themselves. Therefore, me power they will get trade under the old laws chancellor and they transform to the new chancellors then. So basically, then just don't throw spanner into that work and then they make a mockery of that legacy.
So if the university courts be really their swan, individual makeup of the university court, and also they speak in the interest of everybody, they not sell out to allow the Ministry of Technical and Higher Education for probing. You think so that for be there at this stage?
Well, the idea of sellout is everywhere since biblical times. Even Jesus then betray him. So not a new concept. So we get traitors, we get people that we sell out, we get people that we betray. Because interestingly, and this is the irony, you get non-academics then at the court. We're really peeved, very angry about tweeting the opponent, saying, all right. And we have some academics where they collaborate with the ministry because of personal reason, because of sentiment, and because of personal interest. Okay. But this is, it cuts across. It happens everywhere. Okay. So it's not just unique to the University of Sierra Leone.
James Tambalebi, Public Relations Officer for the dissolved University Courts, they state their position. The program Good Morning Salon, they continue 8:16 at the time. We go for a break, but quick, we want to announce to the public, according to the production team, as this issue they unfold, the Radio Democracy don't try to forget the side of the Ministry of Higher and Technical Education for explain their own position on this, but not get in it for Can at the studio for can talk on this issue. The program Good Morning Salon, they continue to go for a short break.
UTB, Union Trust Bank, the game changer don't come. As we the lead, others they follow. And just with your mobile phone, you will transfer and receive money with ease, speed, and safety. UTB don't make it possible for collect money now.
Women who are disproportionately affected by these offenses.
Okay, looking at the issue of petty crime or offense, different people get a way how they can interpret them or call them. As you dare now for talk about this issue and something on the campaign against. In your legal words, how you will best describe petty offense then?
Okay, so this not to me young words some but within the experts, like I said, in the African Commission, and we on study now. And by the way, Saptimeka prefaced with this comment that when we start this program in 2017, this project in 2017, we undertake a study, a baseline study. Across the country, we look at the number of cases before the courts, especially the magistrate courts. Of the 718 cases we captured, 33% of them, we call them petty offenses. Now, back to your question. What are petty offenses in the context of Salon? These are offenses where the laws are create, but they're vague, and because they're vague, sometimes, or most times in fact, they can be wrongly applied by law enforcement. And also the punishment within the method for them offenses there is disproportionate, to the gravity of the offense, you understand? And invariably they lead to violation of human rights. So now them four ingredients now we get for characterized petty offenses.
Okay, in line with that, you can state some example of, any crime where somebody will commit we fall under petty offenses. So
keep in mind, I don't use some characteristics of petty offenses. What we do this study, when are the offenses who call petty offenses? We say minor traffic offenses, for example. Like you they drive, you not get park light. Don't get me wrong, we're not saying you for drive without a park light. We know they say if you obstruction of the traffic not to offense. No. We are saying the punishment, you understand, disproportionate.
That is too big for the
too
offense.
Too big for the offense. Then one. In terms of wrong application of the law, now you cannot really say, person, you can't take that. Musa, when I day you jam. They say, Musa, let me buy 100,000. Where my salary come, I go pay you. Then salary cannot pay Musa. The next thing Musa they do, if they wrong with the police, this is not a purely civil transaction I don't get. Now debt. Now civil courts for handle them. But because in we laws we get with you, there's an offense who get with and call obtaining money or goods under false pretense. You now go to police and talk say, Musa talk say large get money, they go buy clothes and can't give me back the clothes or something. You create a story, and then the police involved now. Now something that be purely civil transaction, then convert into criminal, they arrest you, then detain you, you go down. And at that, they happen most times. Now, ultimately, like I said, why could they even call them poverty? These are poverty offenses. It affect and say, Braha, the left free. You understand? A driver go. You, when a young man or young woman, mostly young women, you they walk along the beach, they wait for motka or they fen keke or fen okada. There's a police van where they driving, pick you up, bam, they say waiting, loitering. Because even the law, the way it was drafted is so vague that they can arrest you for loitering because you have to give an account of yourself according to the text of the law.